Thank you. Right. Welcome everyone to the meeting of the Public Licensing Committee, Tuesday, the 14th of November, 2023. I will remind everyone present that this meeting will be live streamed as well as recorded via the internet, and this recording archived for future viewings. Okay. I will now move on to the agenda for today's meetings. Item number 1 is apologies for absence. I have apologies from Councillor Wilkinson. Do we have any other apologies tendered?
There were no more apologies formally received, Chair.
Right, thank you.
Can I give Councillor Haynes' apologies, or is he here?
He's here.
Okay, I will give him then. Sorry.
Right, we'll move on then. Item number 2 is the minutes of the meeting held on the 17th of October 2023. Do any member wish to raise any matters arising from these minutes? No, I can't see anything. If not, I'll remove these as a true record. And can I have a seconder, please?
I'll second that.
Right, thank you. Right, item number 3 is to receive any declaration of interest and the nature of such interest under the Council's Code of Conduct. Does any member wish to make any declarations of interest?
There were no declarations formally received prior to the meeting, Chair. Thank you.
Right, thank you very much. Right, I'll move on now to the main item of the agenda, which is item number 4, which is a report of the Operational Manager stroke Legal Services, which is of the Commons Act 2006, and an application to register land as town or village green, land at Ringwood Crescent, St Athan. You will have all seen in depth the paperwork of this item and the executive summary starting on page 1. I will now hand over to our principal lawyer, James Doherty, to take us through this application, etc. James.
Thank you, Chair. Morning, members. So this item is in relation to an application to register land at Ringwood Crescent, St Athan as a town and village green under section 15.2 of the Commons Act 2006. The land is split into 2 parcels, which are shown on the plan at page 20 of the report. Should have it in front of you. There's a fairly detailed report which includes the application materials and the objections, but what I'll do is I'll just run through a summary of the position and the recommendations. The application is made to the council in its role as the Commons Registration Authority, and there's a delegation to this committee for making decisions in relation to that function. The application was received in February 2023, and after being publicised by the council in accordance with the relevant legislation, an objection was raised by Annington Property Limited, who are the owners of the land. Paragraph 1.2 of the report, sets out the legal tests that are needed to be considered by committee in relation to whether an application should be successful or not. And as you'll see there, section 15.2 of the 2006 Act says that the applicant must show that a significant number of the inhabitants of any locality or of any neighbourhood within a locality have indulged as of right in lawful sports and pastimes on the land for a period of at least 20 years, and they continue to do so at the time of the application. So this element is generally split into 3 sections, the first being the number of inhabitants of the locality or neighbourhood within a locality. For this application, the locality was described as the ward of St Athan. The indulgence of lawful sports and pastimes as of right is the critical point in this application, we would suggest. As of right means that the applicant or the people who are claiming the town and village green must have undertaken those lawful pastimes without secrecy, without force, or without permission. And it's the without permission element that was to be focused on in this application. There is evidence within the application, or there's a spreadsheet within the application which has the names of 160 people, and you'll be able to see there where they are in the locality, identifying what they have said that they have done on the land in question in the 20-year period, and that is primarily for walking, dog walking, picnics and ball games. The spreadsheet of evidence or of respondents is contained on page 211 of your report. The objection received by Annington Property Limited, who are the landowner, is contained in full on page 228 of the papers, but is summarised in paragraph 1.9 of the report. But fundamentally, the objector claims that the applicant failed to identify a proper locality, and that in any event, the user evidence of 160 persons did not amount to a significant number of the inhabitants of the locality. They note that the use claimed was not as of right, but rather by right, i.e. with permission, since the use by residents of numbers 1 to 8 Ringwood Crescent was permitted by the express rights contained in the transfers of those properties from Annington Property to the owners. There are examples of the transfers at page 257 of the report. Furthermore, there were signs on the land which expressly permit the use by the public of the land for recreational purposes, and that these signs had been present on the land since at least September 2009, which obviously cuts across the 20-year period. There are copies of images of the signs contained at page 284 onward. So there's a map on page 284 of the report showing the locations of the signs, and the signs themselves are contained in the pages immediately following that to identify what has been written on those signs. And I think as an example, I'll be able to read out the content of those signs for you. Just bear with me. So the signs are saying this is private property and there is no public access or right of way without the permission of the owner. The owner hereby permits access by members of the public onto the land for recreational purposes only at their own risk. The permission may be revoked at any time. And there's a copy of that sign in Welsh as well on the same signpost. There were also a number of those signs, and then also notices prohibiting the exercising of dogs on the land. The objection was provided to the applicant, who did not seek to challenge the fact that those signs were on the land or the content of the signs, but did make mention of the fact they didn't believe the signs to have been erected by the property owner, i.e. Annington Property, but that doesn't seem to be a relevant point in this matter, because the signs clearly refer to the landowner, and had the landowner not wanted those signs to be there, they could have removed them. And the final point of the objection is that the evidence submitted failed to provide sufficient evidence as to the nature and timing of the recreational uses claimed and the areas of land to which it related. So the council's officers have reviewed the evidence that has been received from both the applicant and the objector, and the council legal officers' views are set out on paragraphs 1.12 onwards. And the view is that the critical point in the determination of this application is in relation to the use of the land as of right or by right. It's the officer's view that the applicant has failed to show that the use has been as of right, and rather that the evidence that we have before us clearly shows that the use of the land was by right, i.e. permission had been expressly granted by the landowner for the public to use that land for recreational purposes. In order to confirm this understanding, legal officers sought external legal advice, and that is summarised in paragraph 114 of the report, which states that the council's advice is that the council's advice is that the council has discretion as to how to decide the application, as long as it is satisfied it has enough information to determine the application, and if it doesn't, to determine the reasonable steps to obtain sufficient information. As I said, the council officer's view is that the evidence in this matter is quite clear in relation to the use of the land as of right or by right, by virtue of those signs being in place and having been in place since at least 2009, which would cut across the 20-year period that is required for the applicant to prove that the land should be registered as a town and village green. The recommendations for committee are therefore, just find them on my report so I can read them out correctly. The primary recommendation is that committee accept the conclusions in connection with the application and determine that the application to register the land as a town or village green be refused because the applicant has failed to satisfy the statutory tests under section 15.2 of the 2006 Act for the reasons discussed this morning and set out in the report. In the alternative, if committee feels that they do not think that there is sufficient evidence, or that further evidence would be potentially be uncovered, then there is an option to not accept the conclusions and refer the application to a non-statutory public inquiry, including the recommendation resolution for the appointment of a legally qualified and suitably experienced independent chairperson to hold the inquiry, to then prepare a report on their findings, which would then be reported back to this committee in the future, and then also a recommendation that the council would meet the costs of holding that inquiry. So I think that summarises the position as set out in the report. If there are any questions, I'm happy to take those.
Does anybody member wish to ask James any questions? Councillor Bruce.
Yes, you mentioned the whole of the ward. Is that the whole of the ward of St Athan?
Yeah, that's my understanding. Yeah, that's what they applied on the basis of.
Right, so they applied on that basis, right? Okay, okay, thank you.
Does anybody else wish to make any queries?
Yes, please, Pam, if you don't mind.
Who's that?
Yeah, I'm looking at appendix BV111. Right, and it's a list of residents who have said if they've used the site before for games, balls and everything, or have not used the site. Now, I've gone through every single one of these pages and not one single person on it have said they have never used this site in St. Athan. So I just don't get why we aren't granting in this. Sorry. If the residents are using this as a playing area, as playing football, walking their dogs, doing everything, to me, isn't that the whole purpose of a village green?
So so I think that would be the basis under which the evidence that would be required, but it only satisfies one part of the legal test. So the legal test is that you must have, firstly, a significant number of the residents of a locality, of the inhabitants of a locality. That point, I think, is being challenged by the objector, although in relation to this report and the recommendations being put before committee, we haven't dwelt too far on that, because actually the critical point is that the use must have been as of right. So it must have been without permission. And the issue here is that there is clear evidence that the landowner, Annington Property, has given permission for the public to use those areas for the purposes of public recreation through the signs that are erected across the site and across the two parcels of land. Therefore, if permission has been granted, it is not capable of being registered as a town and village green under the strict legal test set out in section 15.2 of the Commons Act.
Okay, thanks.
Hi there, sorry, it's Andrew Speed. Could I just interject if that's okay?
I think so. Matt, I think there's sort of a process in there for sort of, I think Mr. Speed gets a chance to speak in a moment, doesn't he?
Yeah, that's correct.
Yeah.
The chair's asked for questions and comments from members at the moment, Mr. Speed. So the chair will bring you in to make your statements, and questions will follow at that point.
Okay, thank you.
Thank you.
Do any other members of this committee wish to raise any issues? No, perhaps it's most appropriate now we bring in the ward member, Councillor Haynes. Oh, Councillor Norman.
Sorry for the late application. I can't understand why we're challenging something that's been brought to us by a legal representative who has far more knowledge on this topic than we have. I have no planning knowledge. I have no knowledge of how a barrister works or what have you, but we have paid to have a barrister's report on this, and yet we're still challenging it. I'm sorry, I don't understand that. But there probably somebody, maybe Councillor Morgan can enlighten me on this, but I don't see how we can challenge something that's been given to us as a legal document, and yet people are trying to challenge it.
Well, so the report is there, as I say, it sets out sort of your officer's views and provides recommendations. Ultimately, the committee is the decision-making body, and if the committee feels that there is insufficient evidence or it has queries regarding the detail, then it's within its right to come to a different conclusion to the officer's recommendation. Although in this instance, officers are fairly confident that this is a relatively clear-cut matter, and that both sides have been given the opportunity to submit evidence and comment on each other's documentation and responses. Is therefore considered that ample opportunity has been provided for any additional information to be brought forward, and that this represents the full body of evidence available.
Thank you, James.
Councillor Bruce, you want to come back in?
Yes, just one further question. Do we know why the landowner is objecting to this being a village green?
Yeah, so it's quite common for landowners to object. Obviously, the imposition of a village green a successful village green application does limit the landowner's ability to deal with their land however they wish. In relation to this matter, the simple fact that an objection has been raised on the technical points submitted and is set out within the objection are such that the objector does not want their land to be registered as town and village green because it feels that it does not meet the tests. Whilst there are provisions for landowners to voluntarily put forward land for town and village green use, that's not the case in this instance.
There's so many houses around there that you would have thought that, you know, people using it every day, it would make a difference. But there we are. I would like to see further evidence myself.
Right, any other members of the committee wish to raise anything? No? Well, perhaps we can bring in Councillor Haynes now as ward member.
Thank you, Chair, and thank you for letting me speak on this matter, and I'll try to be as brief as possible. But I've got a few points I'd like to make. First off, and I think it's page 18, there's a map which might help the committee understand the layout. That area, which is a part of the ward of Flemingston, is about 1.5 miles from any facilities in St Athan. And to get to those facilities, you have to walk down, if you're walking, of course, down the road. There's a nice wide path in front of a runway. That runway is open to the elements all the way to the sea. So in winter, it's not a pleasant walk. Just you understand that it is a unique situation, not often seen in communities. Now, adjacent to this Ringwood Crescent, there's an area called Eastvale, which used to be called East Camp. And like Eglwys Brewis, it used to get all its facilities from the camp because they're ex-MOD sites. Now, those facilities are all gone. There's not a shop up there. There is not a sports facility. There is no access to any facilities at all, apart from a church and a private golf club. There's a sports ground marked on the map, but that's completely derelict now. Now, in the documents we have, it says that there are facilities, all these facilities in St Athan, like the football pitch and the running and the playing area. It's not a park as such. Are off Glyndŵr Avenue, which is in St Athan Village. So you imagine this community is itself. It is like a village in its own right. Now, Eastvale is probably the poorest community in St Athan and probably one of the poorest in the Western Vale. These people are less likely to own cars, more likely to have to walk. So by removing facilities from them, and this is the last green space there, they're hemmed in by new development to the north. Flemingston Court farmland is now about 200-300 houses. There is obviously towards the sports ground, there's a golf club, and then there's obviously arable land, but that goes down to the Thor Valley pretty quickly. Now, on Eastvale, there's about 240 houses. I should imagine most of the responses to this came from Eastvale. So 160 responses in about a 300 house area is quite a lot. Now, I've lived in St Athan, well, I was born there in 1965, and I used that site from about the age of 12, when my friends lived up there. My children have used that site, and I often see children using that site. And if you allow this site not to be a village green, and I can answer Councillor Bruce's question, Annington Homes, which are one of the largest homeowners in the United Kingdom, want to build on it. So that land will go. It will become housing, and housing in an area where there's not a shop.
That's 3 minutes, Chair.
Yeah. So, and the poorest people in the community are going to be hemmed in yet again. Now, Jane Hutt, not of my party, has quoted that East Vale is a pocket of poverty in Western Vale, and I agree with her. And we need to make sure that we protect the facilities for poorer people. And certainly you can back a major conglomerate if you wish, but I would rather back the residents of East Vale and, well, residents of St Athan as a whole, to be honest. One other point, which I haven't been able to read this entire document because I only found out about this come to licensing yesterday, that James mentioned that dog walkers were expressly forbidden from using this land. Well, all my life I have seen dog walkers use that land, and if the amount of complaints I've received about dog poo up in that area is anything to go by, dog walkers are still using this land. So I would say people are using this land without express permission, and I urge this committee to support residents of St Athan and allow this village green. Thank you, Chair.
Thank you. Does anybody wish to raise any further questions? No. Oh. Stephen Jefferson.
Sorry, Mr. Jefferson, the chair is asking for any questions from members at the moment.
Yes.
You'll have the opportunity to do your parts in the same way as we've just done for the local member. Thank you.
Thank you.
Yeah, right. No other further questions from members of the committee then? No, I can't see. Nothing's come up on my screen. Right, we'll move on to people from the outside bodies. I don't know which order we're going to take this in. I can't see who's there at the moment. Is it Mr. Speed?
Chair, it was Mr. Jefferson who'd registered to speak first. So
Right,
if he wants to come on to make his, if you'd like to come
Sorry
onto the
about that.
camera.
I can't see everything on my screen, unfortunately.
That's no problem, Chair. Mr. Jefferson, you've got 3 minutes. I'll give you a quick shout when you've got 30 seconds left to go.
Okay, that's great. I think I can do this in 3 minutes. So I'm Stephen Jefferson. I'm a planning solicitor at Evershed Sutherland, acting on behalf of the landowner of the application land, Annington Property Limited. I only intend to talk very briefly as to the relevant statutory test and to summarise Annington's principal point set out in its objection that was originally submitted. As already noted in the committee materials, the application is made on the basis of section 15, subsection 2 of the Commons Act 2006, namely that a significant number of the inhabitants of any locality or any neighbourhood within a locality have indulged as of right in lawful sports and pastimes on the land for a period of at least 20 years, and they continue to do so at the time of the application. Whilst Annington submits that the application fails to satisfy all aspects of this statutory criteria under section 15.2, it is the as of right element that I wanted to focus on in my representations today, because we submit that it is evident from the papers that the applicant would never be able to demonstrate that this aspect of the statutory criteria, which must be fulfilled, is satisfied. As has already been noted, as of right means use of the land without force, secrecy or permission. It's this third limb of this definition that is most relevant, namely without permission. It is clear that the use of the application land has been with the landowner's permission, and therefore the use is by right and not as of right. This is the case for 2 reasons. First, it was noted that Annington has been registered proprietor of the application site since at least 2002. The application site originally comprised part of a larger estate, formerly MOD land, and Annington sold off various plots within this estate in the early 2000s. Within the transfer to these plots, which these plots are now known as the properties numbers 128 Ringwood Crescent, rights are granted to use the application site for amenity purposes. These rights won't run with the land, and therefore the owners of these properties benefit from express permission to use the application site for these purposes. Second, there are signs erected at the property. These have been in situ for a number of years, in which members of the public are granted permission to use the application site for recreational purposes. Just to clarify the point previously made about dog walking, that was the signs that related to the former children's play area, which used to be on the wider site, but is not currently there. That was, I think, removed a number of years ago. But it's
30
clear.
seconds left, Mr. Jefferson.
Okay. Thank you. We submit that the evidence makes clear that the use of the application site has been with landowners' permission, and that the statutory criteria relating to as of right can therefore not be satisfied. The applicant does not dispute the use of the land for recreational purposes. It just says that it's been with its permission. I therefore respectfully submit that proceeding to a public inquiry would be a necessary cost and use of the council's resources, as the applicant cannot and will not be able to overcome this flaw in the application. I also note finally that this corresponds with the view of the independent legal advice that the council obtained. With all this in mind, I submit that the officer recommendation be followed and the application be refused on the papers. Thank you.
Thank you very much, Mr. Jefferson. Does anybody wish to raise any issues?
Yeah, sorry, Pam. Yes, me, please.
All right, Councillor Hennessy? Yeah.
Yeah, thank you for your presentation, Stephen. One quick question, and I do not know if you can answer this on behalf of your client. If this application is granted and we do not have it as a village green, does your client intend to build on these properties, on this piece of land?
The honest answer is I don't know. But I note that there are rights reserved to use that land for amenity purposes in the transfer. And also, obviously, I guess that question isn't relevant to the statutory tests under what constitutes a village green. And of course, if it did propose to develop that land, and honestly, I don't know the answer to that, but if it did, obviously that would be subject to a planning application, which would be determined on its own merit by the council. So sorry, I can't answer your question, but I guess I'm say that doesn't go to whether or not the land satisfies the criteria of being a village green.
Okay, thank you.
Thank you.
Councillor Franks, you have your hand up.
Yeah, yes, please. Thank you, Pam. Mr. Jefferson, thank you for your presentation. One thing that did catch my attention, you say there was a play area there and it's been removed.
Yes.
Can you say who removed it and why it was removed and why there wasn't a replacement play area?
I can't. What I can tell you is that it's not been there since at least 2009. And this is apparent from the Google images that are in my witness statement. So it's not been there for a while. So it's not something that the current sort of property manager at Annington was able to tell me as to why it's been removed. It's just clear from the 2009 images that there was an area of sort of hard standing that clearly formed part of a children's play area, and I think it's mentioned in some of the previous representations made as part of the application. But this has since been, it's now just grassland as of 2023.
Okay, thank you.
Do any other members wish to raise any queries? I can't see anything there. No? Okay. Thank you very much, Mr. Jefferson, for your report. Right. All right. Well, we have now another outside speaker. Is it Mr.
Right,
Speed?
Mr. Speed. Yeah, that's right, Mr. Speed. It's going to be the same for yourself. You've got 3 minutes to make a representation to the committee, and then the chair can open it up to questions. Thank you.
Thank you, Matt.
Good morning, councillors. Thank you for the opportunity to speak today. I'm Andrew Speed, and I'm speaking on behalf of the residents of Ringwood Crescent, St Athan. I ask you to agree to this village green application and not to accept the conclusions in the officer's report and refer the application to a non-statutory public inquiry. This should include the appointment of a legally qualified and suitably experienced independent chairperson to hold the inquiry. It is considered that the application land has been used by a significant number of inhabitants, and the 160 questionnaires confirming the use of the land is sufficient for the application to be valid. Many people who submitted questionnaires have used the land as of right, and as a result, the application is valid. No signage has been erected by Annington Homes, and the signage that is there is very old, hard to read, and not in plain kind of view in sight. The applications consider that the evidence in the 160 questionnaires does demonstrate that the use of the land has been of character, degree and frequency as to amount to the user of right over a period of plus 20 years up to the date of the application. The applicants consider that the supporting evidence clearly demonstrates that the use of the land meets the tests for the land to be registered as a village green. Case from Annington Homes does not stand up to scrutiny and should be rejected because 1, the use of the application land has been as of right by many of the questionnaire respondents, and 2, at least 20 years use has been adequately evidenced. For these reasons, the council must register the application land as a new village green. The conclusions of legal advice obtained by the council are not binding, and I ask you to consider the concerns and issues of local residents and allow these matters to be addressed in detail at a public inquiry. We have a duty to support and protect the interests of local people who use this land and recreation, leisure and sport for recreation, leisure and sport. The protection of this land for the local community is very important, and I ask you to consider the matter from our position, where ultimately we are faced with the loss of access to this important and beautiful green space. Thank you for listening to me.
Thank you very much, Mr. Speed. Does any member wish to ask any questions of Mr. Speed? Councillor Norman's got a hand up.
Thank you, Chair. Good morning, Mr. Speed. You just in your statement was saying about the illegibility of the signs. Well, the photographs we have in front of us, the signs are very legible, very easy to read. And as our representative said earlier, are in both English and in Welsh. So I'm sorry, I can't agree with your statement on the illegibility of the signage.
Okay, I've personally been out there and spoken to people on the field, and they've not even noticed the signs. So I suppose it's if you focus in on the sign and actually walk over to it and take a photo, then that view would be totally different to actually walking on and accessing the field.
Thank you.
Does anybody else to ask any further questions?
Could I just ask Stephen Jefferson? I think it's been highlighted that there was consultation last year to do with housing on the site, but he's just voiced that he knew nothing about it.
Yes, that's right. I genuinely don't know what the latest position is with regard to the proposed plans for that application. As I say, I'm aware that there are rights reserved in transfers for the use of that land for recreational purposes. But ultimately, I guess my submission is that that's not relevant to the criteria of whether or not this is this application satisfies the criteria in the legislation to be registered as a village green.
Not relevant, but if it's been previously discussed, then obviously you're aware of that fact, and you just voiced that you weren't, is all I'm just pointing out.
Yeah, as in I generally don't know what Annington's intentions are with that land.
Okay.
Yeah, but I, as I say, I submit that it's ultimately not relevant to this particular application.
Right. Does anybody wish to raise any further queries or questions of Mr. Speed? No, I can't see that. Thank you very much, Mr. Speed.
Thank you.
I heard somebody talking then.
Chair, did you want me to just run through some of the points that have been raised there?
I think it might be a good idea, just to refresh our minds. Yeah.
So if I take them broadly in the order which they came up, I note that Councillor Haynes focused on the availability of alternative sort of public open space within the St Athan ward. whilst that, may be a very live issue in terms of the local community, for the purposes of this application and the determination of this application, those elements are not relevant. The only relevant matters can pertain to the specific evidence supplied in relation to this site. Ultimately, the provision of public facilities is one for is a political one, and outside the remit of this application. The whether or not the landowner is proposing or has plans to propose a planning application for the land for housing and or any other thing that it wishes to do on its land, again, is not a relevant consideration for whether or not to find that this land is a town and village green. Ultimately, the legislation is very clear in relation to the application must stand on its own 2 feet and is not there as a vehicle to stop development. It is there to enshrine for perpetuity the any areas of town and village green that meet the relevant tests. There we going. There was comment regarding the transfers and the rights that are granted within those transfers to the owners of properties in the area. Again, if any planning proposals was to come forward to develop that land in a way that was inconsistent with the rights that were given in the transfers, there would be a legal recourse from the owners of those properties against the landowner. I'm making no comment as to whether those rights exist within the transfers or not, because again, that would be a matter that would sit outside of the determination of this application. In terms of the points raised by Mr. Speed, again, I think I would echo the views of Councillor Norman in relation to the signage, which I think the images that we have of the signage are legible in English and Welsh. I think if councillors are minded to look at their papers on page 284, there is a plan which shows the locations in which various signs are located on the site. I think there are seven points at which signs are located. It would not be reasonable for the signage to be such that it didn't matter from where you accessed the land, that you could always see a sign. However, I think the view of officers is there is sufficient signage and it's in the sort of most appropriate places in terms of the view of the site, that it is sufficient for the landowner to be able to rely on the content of those signs as granting permission for the public to use that land with their permission. I think that, from our view and the view of external counsel is that in the absence of additional evidence to prove that those signs have not been there, which seems to be accepted, then, as has been stated, the chances of this application being successful at inquiry are very slim, and that we feel there is sufficient evidence at this stage for committee to make a decision to refuse the application. Thank you.
Right, I'll bring now the committee member, Councillor Bruce, in first.
Yes, this all seems to be a little bit one-sided on the the landowners' side, and I think I would like to see further evidence coming from the other side, from the Village Green supporters, and that's the way I would like to see things go at the moment. I can't see any. I cannot see my way to saying no to a Village Green, and just my opinion.
Another committee member wishes to speak, Councillor Hennessy.
Yeah, I would like to ask for a recorded vote on this, please, if possible.
Chair, can I come in on this, please? This all should be debated in private and not in front of the applicants or the solicitor. This is a private discussion and should be done off camera and off recording. This debate should not. It's for questions only, not for discussion.
I agree. Yeah. Right, so does any other committee member wish to raise anything? If not, Councillor Haynes has put his hand up. Do committee members wish to hear what Councillor Haynes has to say?
Yes. Yeah.
Only if it's a relevant question to either the solicitor or to Mr. Speed, not as a general discussion matter.
This is not a general discussion matter. It's a point of clarity, if you don't mind, Chair. James sadly misrepresented what I said slightly. I was not referring to facilities in the ward of St Athan. I was referring to the facilities in that particular part of the ward of St Athan, specifically in the sub-ward of Flemingston, which isn't served very well by the facilities of the ward of St Athan. So it's just a point of clarity. I needed to come back in thank you, Chair.
James, do you wish to come back in on that?
Yeah, apologies, Councillor Haynes. I didn't mean to misrepresent what you'd said. And I suppose the point that I raised still stands insofar as the provision of other facilities within a locality is not a matter for consideration in terms of determination of this application.
Right. Okay. Right, there's no further discussions. You will now see two recommendations you have on page 2 of the report. I don't wish to read them out again, but if you want me to, I will.
Chair, can we go private on this, please?
I think we need to.
Chair, apologies. Councillor Michael Morgan's got his hand up a second, but there was a point I just wanted to check with Richard as well, if you don't mind.
No, I was just saying I was waiting patiently for us to retire for debating on this, but we're not ready to make a decision yet.
Yeah.
Chair, as far as I'm aware, this isn't a part 2 matter.
No.
So
thank you, Richard.
It's not for debate in camera.
Yeah, as it's a part 1 item, Chair, it's a decision for the committee to discuss and debate based on the 2 recommendations that you've been given in the report. So as such, it's not something that would be held in private. It would be a decision made in open session.
Yeah, I think it's a slightly different type of matter to that which would usually come before the licensing committee. But I would agree with Richard and Matt that the debate can happen in part 1 in open session.
Thank you, James.
Councillor Morgan, is that a legacy hand, or did you want to say something further?
No, it's another hand. I do have observations to make. Do you want to hear them now, or are you waiting for further comments on what's said already?
I don't know. Has anybody else wished to speak? I can't see.
Councillor Marshalsey's got a hand raised, Chair.
Yeah, it's not come up on my screen, unfortunately. Councillor Marshalsey.
Hi, I just wanted to ask a question. Based on this, I think there was mention of a public inquiry. What is the process for if this voted through or not?
So the process would be if committee members were to decide to go with the alternative recommendation and request a statutory public inquiry, then officers would go away and appoint an external inspector who would be appointed to sort of provide a report. We would then have a non-statutory public inquiry. Usually they tend to follow some months after the appointment, because you'd have provision for sort of logistical issues, and sometimes the inspector would sort of want pre-inquiry meetings to kind of set some boundaries in terms of how procedure would run. There would then be a statutory inquiry, which, depending on the evidence, could run anywhere between 1 and 3 days of evidence, depending on how many people wanted to give verbal evidence. Following the holding of the non-statutory inquiry, the inspector would then go away, produce a report similar to the one that's been before you today, which would then be brought back in front of you at a later date, a later committee date. And again, you'd be asked then to either follow the recommendation of the inspector, in whichever way he reported back, or in the you would still have the ability to find against his recommendations, and then so it could still go either way in terms of how members were to decide it. There's no strict appeal process for a town and village green application, but there would be potential for the decision to be judicially reviewed. And obviously all that's at the cost of, there's no cost to either party in terms of the process. It comes out of the council's purse in terms of the appointment of the inspector, and there's no cost recovery in terms of what the council expends. Each party meets its own legal costs of how they proceed.
Are you satisfied with that, Councillor Marshalsea? Right, thank you. I believe Councillor Morgan wished to come back in.
Yeah, only briefly with a couple of comments, because I know various things have been said about the need or desire to have a village green, and the fact that there aren't facilities for local people, but we can't get sidetracked by the emotion of this. We're dealing with very clear legal guidance on this. We have two very simple or straightforward things to look at: whether or not this area of ground has been used as of right or by right, and then again looking at the evidence as to the number of people who have used it. And I think we have to be conscious of the legal advice that we have been given, and it seems to me quite clear that that there is use of this land, and it is by right, in that the people have been given permission to do it. And certainly in the transfers of the land, there are rights to use the amenity areas, and there are clear signs on the land to say that people are given permission to use the land. It doesn't seem at the moment there's a threat of the land being removed from community use. And as James has said, the fact that there are rights in the title of the land of the owners of the houses at Ringwood Crescent, that those rights would be preserved in any future years anyway. So my concern is that we can't get sidetracked by the emotion and what we would like to see, and that we need to take note of the legal advice that we are given. And the concern, obviously, is if we launch into a public inquiry, there's enormous expense involved in that, which this council will have to meet. And I'm afraid, however much personally I would like to say, yes, let's have another village green, it's not simply a case of people coming forward and saying, well, we want that land as a green, let's have it. You have to prove, and there are statutory provisions and clear case precedent as what you have to prove. And it just seems to me that the applicants are nowhere near that. And I think my view is that this application would need to be refused, and I don't support any application to take it to public inquiry and the expense involved. Thank you.
Chair, sorry, do you mind if I just jump in before Councillor Sivanyanam?
Right, that's fine.
I just wanted to make clear a point that I know Councillor Morgan there referring to provisions within the transfers relating to the rights to access amenity areas. I think I wouldn't want members to be under the impression that there is a cast iron guarantee that the land couldn't be developed on. What I haven't done, there are rights there for people to use the areas. What I haven't done is gone through in detail the actual provisions in terms of whether there is any scope for those amenity areas to be taken in or out of the permission. So what I wouldn't want to do is have people vote on the basis that they think that the land definitely cannot be developed because of those rights, because I'm not saying that, but I'm also not saying they couldn't. What I'm saying is it would be a private matter for those landowners to take separately, but in any event, that isn't a relevant consideration for the application. Thank you.
Thank you very much. We're now bringing Councillor Siviano.
Thank you, Chair. I mean, really, Councillor Morgan has said what I would really, more eloquently than I would have, said what I would like to say, really, which is, you know, I have great sympathy with the residents there, that, you know, this is a, you know, a piece of land that people are using every day, and there's this idea of, you know, having it as a village green is, you know, is an aspirational one, and one that, you know, they're entitled to have. However, we have to be guided by the law, and I think James has outlined the fact that, you know, if we did accept this, and this did go to the independent inspector, this would be at a significant cost to the council, which, you know, we all know here that would be a very difficult cost to bear, if we could bear it at all. So, you know, whilst I do have sympathy with the residents, you know, I think the law is very clear on this, and we need to follow that and officers' recommendations. Thank you, Chair.
Right. There's two more people put their hands up, and I believe the next one would be Councillor Driscoll.
Yeah, thanks, Chair. The last two speakers have shown great sympathy with the village green and keeping open spaces. I'm of the opinion that we can actually help them. Perhaps we can let the public independent or public inquiry decide. Finances shouldn't come into it. We haven't been told a figure. And I'm quite happy to take a chance on public inquiry just for the benefit of the residents of St Athens. Thank you, Chair.
Right. Councillor Bruce had a hand up, but she removed it.
Yes.
Oh,
Sorry.
you still
Yeah,
want to speak there?
Excuse me, I've got a frog in my throat. Vince said exactly what I was going to say, that finance shouldn't come into it.
Right. Okay. Right then. I think we've had a good discussion on this. Mr. Speed has put his hand up, but I don't know whether he's entitled to come back in on anything.
It wouldn't usually at this point, Chair, but it would be your discretion.
No, I think we've had a full discussion on this item, and well, we've got the two recommendations in front of us, which is on page 2. I don't intend to read them out again, but if you wish me to, I will. Okay, so everybody's aware of what these recommendations are? Yeah, okay. Well, I would recommend that we opt for recommendation 1. Do I have a seconder for this?
Second.
Right. Do we need to go to a vote for that?
I think Councillor Hennessy requested a recorded vote on it, Chair.
Yeah, I don't know whether it was seconded. I can't remember.
Okay, just
That was going to be my next question, Chair. We had a proposal for a recorded vote, but did another member want to second that?
I'll second it.
I'll second.
Right. Okay, then we'll move to option number 1, and we'll vote on that option. So I'll hand over to Matt to take us through that.
Thank you, Chair. I'll go through the roll call alphabetically for this. So can I start off with yourself, Chair?
I will move recommendation 1. And I'll vote for that.
Thank you very much. Apologies, my page is just frozen. I will refresh that. Technology is letting me down.
Technology is wonderful, isn't it?
It is. It is. Councillor Bruce, please.
Against. I'd like to see further evidence.
Thank you. Councillor Burnett.
I'll agree with officer recommendations.
Many thanks. Councillor Driscoll.
Against officer recommendation.
Thank you, Councillor. I'm not sure Councillor Fisher is present. Let me just double check. No, Councillor Fisher isn't present. Councillor Franks.
Against.
Thank you, Councillor. Councillor Goodjohn.
For the officer recommendation.
Thank you, Councillor. Councillor Hamilton.
For the officer's recommendation.
Many thanks. Councillor Hennessy.
Against the officer's recommendation.
Thank you, Councillor. Councillor Marshalsea.
For the officers' recommendations.
Thank you, Councillor. Councillor Morgan.
For recommendation 1.
Thank you, Councillor. Councillor Sivnyan.
For recommendation 1.
Thank you, Councillor. Councillor William, I don't think he's present. Let me just double check. No, and Councillor Wilkinson's given her apologies. I make that.
I haven't yet voted.
Oh, I'm sorry, Councillor Norman.
For the officer's recommendation.
Thank you for correcting me there, Councillor. Let me just tally those through.
Chair, when he's tallying, I've just realised I should have given apologies for Stefan William. So if it's not too late, I so do.
We'll leave that up to
Lovely.
Matt.
Lovely. Thank you very much. I make that 9 for and 4 against, Chair.
Right. Well, thank you very much for everybody with this participation. It's been a lengthy meeting, but a well-deserved one. And so we can now move on. Item number 5 is any items the chair has decided urgent under part 1. I have no further business to take under part 1. And item number 6, any items the chair has decided are urgent under part 2. And you'll be relieved to know I have no further business to go through today. And I thank you all for your attendance and participation today, which has been quite difficult, but very interesting. Thank you very much, everybody.
Thanks, Chair.
Thank you, Chair.
Thanks.
Thank you.
Thanks, Chair.
Thank you very much, Chair.
Bye.
Take care.
Bye-bye.